Hello students, today we will discuss the rule of absolute liability. The synopsis for today's class is MC Mehta versus Union of India, absolute liability, Bhopal gas tragedy, and also we will discuss the difference between the strict and absolute liability. Okay, now let's discuss the case of MC Mehta versus Union of India, which was held in 1987. The rule of absolute liability was laid down in this case. Okay, the other name for this case is oleum gas leak case. So let's discuss the fact of the case. First of all, Shriram Food and Fertilizers, that was actually a pesticide industry in Delhi. So in 4th and 6th of December 1985, twice, that is 2 times, there was a leakage of a gas called oleum gas. Therefore, it is also called oleum gas leakage case. So the gas leaked from the sulfuric acid plant. What happened? Because of the leakage, it resulted in death of an advocate who was practicing Tis Hazari. Tis Hazari is basically a name of the district court in Delhi, and it also caused injuries to others. So the apex court stated that the defendant would be liable for the damages caused. So the rule of absolute liability. Number 1 point. If the person should be engaged in a hazardous or a dangerous activity, so the activity should be dangerous, and if any harm is caused during the carrying of such activity, then the person who is engaged will be held liable. The rule was laid down in the case of MC Mehta versus Union of India in the year 1987, and also followed the Supreme Court while deciding the case of Bhopal gas tragedy case, which happened 3 years earlier, that was in 1984. This is a picture of the newspaper report with the headlines of the case, which has the picture of the industry, the plant. Can you see? Now we will discuss Bhopal gas tragedies case 1984. Here there was a leakage of MIC or methyl isocyanide gas from 3 storage tank of ULCL, which was basically a pesticide plant in Bhopal, Madhya Pradesh, and it was also considered to be the world's worst industrial disaster. Why? Because over 5 lakh people were exposed to the gas and at least 3,000 people died, and so many of them were injured. Okay, here I have 2 pictures. The left picture, you can see so many people were affected by the leakage of this gas. Okay, and you can also read what are the effects of the MIC gas. And on the right side, you can see a very famous picture of a headline, that is of a baby. It not only killed newborn babies but also severely polluted the drinking water, the soil, and killed many animals also. Okay, settlement of the case. As you can see, the Indian Supreme Court directed UGC and government to settle the case for compensation of $470 million. That was around 350 crore rupees. But the Madhya Pradesh High Court reduced the interim compensation to 250 crore rupees. And it is still silent on the settlement of environmental damage it has done. Now let's discuss the difference between strict and absolute liability. As you can see, I have written 4 points over here. First and foremost difference is hazardous or inherently dangerous activity should be there in absolute liability, but in strict liability any other activity can be done. Okay. Point number 2, escape is not necessary. The liability can be within and also the premises, whereas in strict liability escape is necessary. Point number 3, which is the most important point, I also said in the previous slide, that is there is no exception to the rule of absolute liability. That is why it is absolute liability, whereas strict liability has exceptions. That's why it's strict liability. Okay. Point number 4 applies to non-natural and natural uses of the land, but strict liability applies only to the non-natural use of land, not the natural use of land. But it is not so in the case of absolute liability. So with this, we have completed the topic of strict and absolute liability. Thank you so much for listening to the video. Please give your valuable feedback in the comment section, and also you can contact me if you have any doubt about the video.